Bismillahirrahmanirrahim. My name is Nur Farhana binti Muhammad Zain. So today I'm reviewing a case of Malayan Hat and Premier Expense Number Hat and others, which is the owners of an or any other persons interested in the ship or vessels, the Zuhairi and Nasuha. So the area of law involved in this case is under frustration. It is established due to subsequent change in circumstances. The contract is rendered legally or physically impossible to perform, not due to the act or default of either party. Hence, the parties to the contract are discharged from the performance of the contract. In Malaysia, this law is covered under Section 57, Clause 2 of Contracts Act 1950, which stated that a contract can be frustrated and discharged without breach or default of either parties. The elements to be fulfilled under this kind of law is firstly, parties must prove that they have made no provision for such events in their contract. The next one is the acts become impossible to perform, which the example can be seen in the illustration of B, D, and E of Contracts Act 1915 and 57. And the last one is frustrating event happens after formation of contract, which under illustration D of Contract Act 1950. So for the citation of the case, 2013, Volume 8, MLJ, page 32. The plaintiff in this case was Malayan Banking Berhad, while defendants was Premier Expense Niaga Berhad and others, which is the owners of an or any other persons interested in the ship or vessels, the Zuhairi and Nasuha. The court that heard this case was High Court of Kuala Lumpur on 24 October 2012, and the judge that decided this case was Nalini Padmanathan judge. So for the material facts of the case, the plaintiff granted a loan facility to part finance the purchase of the vessels known as Zuhairi and Nasuha to the first defendant on favor of the second defendant. As for the security of the loan, the vessels has been the mortgage and several guarantees were given by the directors of the second defendant. However, the first defendant defaulted in payment and the plaintiff started to foreclosure the vessels. But at this time, the plaintiff realized that mortgage never been registered for them. Further, the plaintiff got to know that the vessels had been transferred and registered in favor of third defendant. The plaintiff filed an action to arrest the vessels. However, the fifth defendant intervened, saying that the vessel had been transferred to them by third defendant. An injunction from the court has been ordered to prohibit dealings with vessels by the consent from plaintiff and fifth defendant. But later on, the fifth defendant sold and transferred the vessels to the sixth defendant pursuant to a bill of sale and executed a mortgage in favor of the seventh defendant for a loan facility to finance the vessels from the fifth defendant. They registered their interest in the vessels with the Port Klang Marine Registry. Hence, the plaintiff brought an action against all of them claiming the said vessels. So the legal issues arose in this case was, firstly, was there an equitable mortgage in favor of the plaintiff? The second one is, if an equitable mortgage subsisted in favor of the plaintiff, what was the effect of the transfer of the vessels in breach of the contractual obligations? And the next one is, were the transfers effected to avoid the registration of the equitable mortgage? The fourth one is, what was the effect of a transaction effected in breach of a court order? And the last one is, whether a registered mortgage has priority over a prior equitable mortgage. So for the arguments from the plaintiff contended that they have equitable mortgage for the loan given. He said that the equitable right on the vessels arose at the time the loan facility was released by the plaintiff to international broking services pursuant to a letter of credit. They also argued that the transfer of ownership from second to third defendant and third defendant to fifth defendant was void if there is equitable mortgage in favor of the plaintiff regarding the vessels. They also stated that fifth defendant were in contempt of the court order when they transferred the vessels to the sixth defendant. In addition, they also said that the transfer of ownership from to 6 defendants was void due to frustration as the 5th defendant was breached the injunction ordered to them. Meanwhile, on part of the third defendant counter-argued that plaintiff never responded either to choose vessels or landed properties as security for loan. They contended that the offer from the plaintiff never stated that the vessels or lands were to be the loan securities as the plaintiff were given 2 vessels to be mortgaged, along with some properties belonging to second defendant and joint, and several guarantees given by the directors of the first defendant. They also stated that it is plaintiff's own negligence not register the mortgage. Moreover, both vessels were registered and rightfully transferred to the third defendant as there were no encumbrance of the vessels. So on the part of 6 and 7 defendant, uh, they argued that they have purchased the vessels pursuant to a bill of sale. They also a bona fide purchaser for the value without notice about the injunction given to the 5th defendant. They got the finance loan from the 7th defendant and has been registered their interest in the vessels by the 7th defendant. At the time of registration, the vessels were free from encumbrance. They contended that they have rightful statutory mortgage over the vessels and priority over all the unregistered mortgage before. So for the ratio decidendi, for the first issue, the court was referred to the case of London Country and Westminster's Bank Limited and Tompkins. This case has provided the definition of mortgage and equitable mortgage, which mortgage are a form of security conferring an interest in property, indivisible in performing the condition of paying some money. The court also applied the doctrine of equity where the court must be fair and justice towards the parties. Yes, the plaintiff should be registered the mortgage, but they negligence in doing so. But this does not mean that they lost their right over the vessels as the vessels were the equitable mortgage. Security loans in exchange of them provide financing help to purchase the vessels. For the second legal issue, the court had referred to the case of the Shizel. This case was talk about the position of bona fide purchaser for value without notice whether they can be liable or not. The judge decided that legal mortgage is enforceable, but equitable mortgage will not be enforceable against bona fide purchaser. However, in this present case, the court found out that the third defendant were not bona fide purchaser as they have close relation to the first and second defendant, as they should have all the information regarding the vessels through first and second defendant. So for the ratio for the third issue, the court referred to the case of the Enfield, Barbary Panama SA and another, and Cross Oceanic Navigational Service Pte. Limited. The judge in this case decided that the court is entitled to look at the transaction and determine the true beneficial ownership of the vessel. However, the plaintiff did not carry the true face of bona fide purchaser. Same goes to the present case where the third defendant were not bona fide purchaser. As second and third defendants companies were interrelated, and it is possible that they know regarding the equitable mortgage in favor of plaintiff. This clearly shows that manipulation between them in order to transfer the vessels. Hence, the court agreed that the transaction of transferring the vessels from second defendant to the third defendant was to avoid priority of the equitable mortgage. Next, for the fourth issue, the court was referred to the case of Standard Chartered Banks, where the judge also referred to the Section 57, Clause 2 of the Contracts Act 1950. As I already mentioned before, regarding the frustration of the contract, it is also stated that the contract will be frustrated in two ways, whether it is impossible to perform or unlawful, where frustration should be caused by supervening and subsequent events occurring after the formation of the contract. However, self-induced frustration does not discharge a party from any obligations. In addition, the court also referred to the case of Davis Contractors Limited and Fareham Urban District Council. This case talk about the doctrine of frustration, as frustration occurs whenever the law recognizes that without default of a contractual party incapable of performing the contract because of circumstances that could not avoid it. The present case, the injunction was made before the transaction by fifth defendant and sixth defendant. Hence, it cannot be considered under frustration as the elements is not fulfilled. It is also unfair to place burden on the sixth defendant as they were only bona fide purchaser without knowing about the injunction between plaintiff and fifth defendant. However, the fifth defendant may be charged of contempt of the court. And for the last legal issue, the court derived the decision by referring to Section 43 and Section 41 of the Merchant Shipping Ordinance 1952, which stated that if their mortgage has been registered in the same ship or shares, the mortgage shall have priority in the order of the date on which the mortgage is recorded in the register book. To strengthen this, the court also referred of the Harlock. The judge in this case stated that there is no liable for a purchaser who purchased from an owner the registered property without any notice of fraud. Hence, if purchaser got possession of property which he thought that he was getting honestly, the court has no right to interfere with him. The court also referred to the case of Buckley and Co. Limited and Pool. It has been decided that it cannot be disputed that the purchasers acquired a valid title to the shares. By relying all of the cases mentioned above, the judge concluded that the seven defendants who has statutory mortgage over the vessels would have priority of claim over plaintiff who only possess equitable mortgage. It is on plaintiff default for not registering the mortgage. So, decided to refuse or dismiss all of the relief sought by the plaintiff except for prayers J and O and P, which allowed, and the damages to be assessed by the registrar. So for the analysis, I agree with the decision of the court. The plaintiff cannot success in their claim because it is negligence on behalf of them for not registering the mortgage. So even they have equitable mortgage, but the registered one will take precedence over unregistered mortgage. In addition, it is not relevant to blame the 6 and 7 defendants as they are only the bona fide purchaser for the value without notice, as they did not know about the transaction happened before. It can be compared to the case of the Jargo Sawit's case, where the court held that the party were not bona fide purchaser for value without notice. Hence, the court can dismiss the appeal. However, in the present case, the fifth defendant should be liable because they was against the court's order, but not frustrate the contract between fifth defendant and sixth defendant. So to conclude, this case is very important to show the implementation of elements under frustration, which the court has made it more clear regarding it in this case. Hence, this case can be referred as precedence by the future cases. So I think that's all from me. Thank you.